get a massive development out of Virginia that every gun owner in America needs to pay attention to, because this is no longer just another anti-gun proposal.
Well, friends, she did it. On Friday, Virginia Governor Abigail Spanberger, old Grabby Abby herself, and her poison pen signed into law legislation that bans the purchase, sale, and transfer of certain assault weapons. That's right. As of July 1st, it is illegal for Virginians to buy or sell AR-15s. Today, we're talking about Grabby Abby's new law, the avalanche of lawsuits that have already begun, and how this and what I think is the upcoming SCOTUS decision is going to torch her future political ambitions because, as we all know, she wants to be president. Hi, everyone. I'm Terry Christoph. I'm a fed-up Gen Xer and ticked-off Virginian, and I am behind this microphone right here so that you and I can talk about what's really going on. Welcome to Smart Girl Politics. All right, let's just start right here at the beginning. What is the law that she just signed on Friday? It's called Assault Firearms and Certain Ammunition Feeding Devices, Purchase, Sale, etc. Prohibited/penalties. All right, this is what's going to happen. Purchase, sale, transfer, etc. of assault firearms and certain ammunition feeding devices prohibited. Here are the penalties. Creates a Class 1 misdemeanor for any person who imports, sells, manufactures, purchases, or transfers an assault firearm, as that term is defined in the bill with some exceptions, and prohibits a person who has been convicted of such violation from purchasing, possessing, or transporting a firearm for a period of 3 years from the date of conviction. The bill provides that an assault firearm does not include any firearm that is an antique firearm, has been rendered permanently inoperable, or is manually operated by bolt pump, lever, or slide action. The bill also prohibits the sale of a large capacity ammunition feeding device, as that term is defined in the bill. The bill provides that any person who willfully and intentionally sells an assault firearm to another person or purchases an assault firearm from another person is guilty of a Class 1 misdemeanor, and that any person who imports, sells, barters, transfers, or purchases a large capacity ammunition feeding device is guilty of a Class 1 misdemeanor. So there you have it. If you're a law-abiding Virginian, and you feel like maybe you want to swap a gun with a family member or friend, don't even think about it. Abigail's watching. She's always watching. Now, one thing that I want you to know about this bill and the legislation is it's the work of a state senator by the name of Senator Saddam Aslan Salim, who is a Muslim immigrant from Bangladesh. And there he is. This is the guy who introduced the bill. Saddam Aslan Salim, who immigrated from Bangladesh, authored Virginia's new unconstitutional gun ban, attempting to naturalize those who hold beliefs that are incompatible with our Constitution is a recipe for disaster. In this case, disarmament. Denaturalize, deport, defend, Second Amendment. Now, this guy's really interesting because there's another bill he introduced this year that did not go anywhere, but I suspect will next year, that would outlaw Islamophobia. And Islamophobia is anybody that goes, what's Islamophobia? Yeah. So we need to take a little deeper dive into that. So stay tuned for a video along those lines. Now, if you're learning anything from this video, please be sure to like, subscribe, and comment. This helps other Americans learn about the insanity that's happening here in Virginia, and it could happen where they are too. This is an egregious violation of Second Amendment rights of Virginians. Needless to say, the lawsuits are already flying. Professor Jonathan Turley had some interesting points to make about this. He called his article, "Locked and Loaded, Spanberger Inadvertently Makes Case for Striking Down New Gun Ban," which everybody seems to think is going to happen. Virginia Governor Abigail Spanberger is reportedly fuming this week after the state failed to get a single justice on the Supreme Court to support her after she violated the state constitution in her attempted gerrymandering. She's not having a good run. However, Spanberger may have just guaranteed another trip to the Supreme Court when she said the quiet part out loud about the new state gun ban. After the Democrats took power recently, they went on a frenzy of tax and liberal legislative measures. The sharp move to the far left is out of sync with a purple state that remains roughly evenly divided. While Spanberger, who ran on being a moderate, has pushed forward many of these measures, she sought to moderate one bill banning so-called assault firearms. Spanberger released a statement that I am signing this bill into law because firearms designed to inflict maximum casualties do not belong on our streets. We are taking this step to protect families and support the law enforcement officers who work every day to keep our communities safe. While the General Assembly chose not to adopt my amendment that specifically carves out certain firearms frequently used for hunting, I will work with the patrons to clarify this language. The governor's acknowledgement that the law covers, and this is Jonathan Turley writing, a law professor, the governor's acknowledgement that the law covers common hunting models will likely be cited in Second Amendment challenges. If the law is not amended, she could prove the main witness against her own signed legislation. Even with such an amendment, the bill is problematic. I have previously written about my skepticism over bans on AR-15 and other so-called assault weapons. We have the Second Amendment protection of gun ownership with over 490 million guns in private hands as of 2022. In 2008, and this is the important piece, the Supreme Court handed down a landmark ruling in District of Columbia versus Heller, recognizing the Second Amendment as encompassing an individual right to bear arms. The Supreme Court further strengthened the right in New York State Rifle and Pistol Association, Inc. versus Bruen. The AR-15 is the most popular gun in America, and the number of these guns in private hands is continuing to rise rapidly, with one AR-15 purchased every 5 new firearm sales. Needless to say, the lawsuits are flying fast and furious. So we are going to learn a little bit more about these lawsuits that have already begun. And as we all know, Harmeet Dhillon, who is the Assistant Attorney General of the Department of Justice of the United States of America, she has been watching this very closely. And if I can remember, I'll put her tweet up. But she said, "See you in court," after it was reported that Abigail Spanberger signed this into law. But let's go over to YouTube and learn a little bit more about the
Virginia Democrats passed SB 749, and according to this lawsuit, it creates one of the broadest so-called assault firearms bans in the nation. The law criminalizes the importation, sale, manufacture, purchase, transfer, and even public carry of massive categories of semi-automatic firearms and magazines beginning July 1st, 2026. Now listen carefully to how broad this thing is. According to the lawsuit, Virginia's definition of assault firearm includes semi-automatic rifles with detachable magazines and common features like adjustable stocks, pistol grips, threaded barrels, or forward grips. Semi-automatic pistols with threaded barrels, braces, barrel shrouds, or magazines outside of the grip. Semi-automatic shotguns with detachable magazines or pistol grips, shotguns with revolving cylinders, any firearm capable of accepting belt-fed ammunition, and even firearms modified to become one of these categories. Folks, that's enormous. That means that your ordinary AR-15, banned. Your AR pistol, potentially banned. Your threaded barrel handgun, potentially banned. Your standard 17-round Glock magazine for your Glock 17, banned under their large capacity feeding device definition. And yes, Virginia defines large capacity as anything over 15 rounds. I wonder if they're going to take it away from the law enforcement agencies too. Oh yeah, second class right thing. So what the anti-gunners call common sense regulation here is actually criminalizing some of the most commonly owned firearms and magazines in the entire country, the United States of America. And the lawsuit absolutely hammers that point. The plaintiffs cite Supreme Court precedent saying that AR-15s are the most popular rifle in the country. That's not just GOA saying it. That's language pulled directly from a unanimous Supreme Court opinion that was Mexico versus Smith & Wesson, that case. And that lawsuit also points out that magazines over 15 rounds number in the hundreds of millions nationwide. And this is where Bruen and Heller become devastating for Virginia. Because under Heller, firearms that are in common use for lawful purposes are protected arms. And Bruen made clear that the government has to prove a historical tradition supporting modern gun restrictions. And that lawsuit flat out says Virginia cannot do that. Now, here's where this gets even more interesting. The plaintiffs are strategically avoiding federal Second Amendment claims entirely. It's a different path than the lawsuit I told you about this morning. Instead, they're arguing that Virginia's own constitution protects these firearms. And that matters because state constitutional protections can sometimes provide even stronger protections than the federal courts. And the lawsuit points out that Virginia amended its constitution in 1971, specifically to clarify that The right of the people to keep and bear arms shall not be infringed. That's the quote. The filing argues Virginians intended that language to be at least as protective as the Second Amendment itself. Now let's talk about one of the most dangerous parts of the law, the public carry ban. This law doesn't just ban future purchases, it bans carrying these firearms in public. And according to the complaint, Virginians could be criminally charged for carrying these firearms on public streets, sidewalks, parks, rights of way, and basically any place open to the public. And that includes private businesses open to the public. So theoretically, you could carry legally for years and then suddenly become a criminal because Virginia politicians changed the definition. And the lawsuit points out there's no meaningful exemption even for concealed handgun permit holders. And that's a direct collision course with Bruen. Bruen specifically held there is no historical tradition supporting bans on carrying commonly used firearms for self-defense. Now, this is exactly what happens when lawmakers who don't understand firearms try to sound smart and try to regulate them using cosmetic features and scary terminology. And remember, this is the same playbook that we have seen for decades, and it gets rather old, but here it is again, this time in Virginia again. They don't ban firearms based on function. They target the appearance. Threaded barrels, pistol grips, adjustable stocks, braces, features that have little or nothing to do with criminal misuse. Meanwhile, criminals ignore all of it, and they're not held responsible at all. Now, the filing repeatedly emphasizes these are ordinary firearms in common lawful use. And folks, this is key. The lawsuit argues the right to keep and bear arms necessarily includes the right to acquire them. And this is an argument we're seeing gain more and more traction nationwide after Bruen, because a right you cannot exercise is not really a right. If the government can stop the sale, transfer, manufacture, or acquisition of protected arms, then they can effectively destroy the right itself without technically banning possession of anything.
So it sounds like we're going to have lawsuits that challenge on the federal level, the state level, and then there's probably going to be an avalanche of even more than that. So we will keep an eye on it. But there's more good news. Not only do we know that Harmeet Dhillon and the Department of Justice is coming after this law, we have some Commonwealth's attorneys who are the very, very definition of anti-Steve Descano, who are saying that they're not going to enforce this law. Now, my apologies if this is Smith or Smythe County, I don't know, but their Commonwealth's attorney calls the assault weapon ban just signed by Abigail Spanberger unconstitutional. In a message to the Smith, we're going with Smith County Sheriff's Department, Smith County Commonwealth attorney Philip Blevins called Virginia's assault weapon ban unconstitutional. In the message, Blevins says that after careful review of the legislation and existing Supreme Court precedent, that he finds the assault weapons ban that was signed by Governor Spanberger on May 15th to be unconstitutional and unenforceable. He says his oath requires more than mechanical enforcement of statutes and goes on to say, I must exercise prosecutorial discretion, constitutional judgment, and fidelity to the rule of law. He says his office will not support criminal charges resulting solely from technical violations of the ban. And then we also have Spotsylvania County. Spotsylvania County Commonwealth's attorney says he won't enforce the state's new gun law. It's hard to see, but it says, today it has come to my attention that certain legislation enacted by the General Assembly of Virginia was yesterday signed into law by the governor of Virginia, to wit, an assault weapons ban. I write to state that this legislation is inconsistent with the Second Amendment of the U.S. Constitution and Article 1, Section 13 of the Virginia Constitution. These laws are unconstitutional and cannot be lawfully enforced. So, we've already got, I think there's a few sheriffs also saying that they're not going to be enforcing this either. So the house of cards is crumbling, which is good. But how quickly this unfolds, it's not apparent yet. So it's unlikely that anything's going to happen, as far as I understand it, before July 1st when this takes effect. But once it's taken effect, it's going to be a full-on attack on Abigail Spanberger and Virginia Democrats. The big loser here, once again, is Abigail Spanberger. She just lost on gerrymandering. She let it go all the way to the Supreme Court. She knew better, and she did it anyway, and she takes that loss. She crossed her Union foot soldiers by vetoing collective bargain legislation. They're angry. The second smackdown that's going to come from the Supreme Court of the United States of America is the death knell for her political ambitions. She is looking to be a vice presidential contender in 2028, which sets her up to eventually being president. She's getting smacked down left and right, man. She is taking some haymakers from the Supreme Court of the United States. She is becoming toxic political poison to the Democrat Party, which is saying something because the bar is so low, it can't get much lower. And she does not rise to the bar right now because she's poison. Every day she becomes more and more poisonous. She's not making anybody happy. And there she goes. Boom! Anyway, that's all I've got for you today. After you like and subscribe, be sure to drop me a comment down below with your thoughts on Grabby Abby's gun ban. And if you need to catch up on all of this gun legislation, be sure to check out this video right here. Thanks for watching, friends. And as always, be safe out there, okay? I will see you next time.